So back in the conference room, Brian.
Back in the conference room.
Good day, everybody. It is 6 o'clock on Monday. This is the time where Sam Shihab and Brian Burke from the law firm of Shihab Burke, spend an hour with you to go over immigration issue of interest and also answer questions. Today's topic is something that we probably have talked about before or discussed it before, Brian, but it is important because we are coming upon an election and we are going to have a new administration 100%, whether it is Kamala Harris or Donald Trump. And with that change in administration, the government changed their priorities. And therefore, it's a good idea, Brian, to talk about criminal conviction, impact on your non-immigrant visa, and what to do in situations, because decisions, obviously the best thing to do is not to have a criminal conviction or a criminal issue.
That's my immigration lawyer advice. I like that. That's a good start, yeah.
But that's the conversation I had this morning with this wonderful young professor who found himself having one extra glass of wine than he should have, and there was a DUI. Totally he regrets it.
Yeah.
And it's not the kind of thing he does. It doesn't reflect who he is. Feels terrible, but it is on his record, and he has to deal with it.
Not only does he feel terrible, he's feeling really anxious about the future implications of it all, right?
Yeah. So avoiding these things are...
That's step one. You know, if we're doing a list, that's the easy thing. Well, you shouldn't have done that. Too bad. It's here. What are the consequences?
When it happens, what should you do? What is because your conduct and your decision-making process after the unfortunate incident is critical for your future in this country. So we're going to talk about impact of criminal charges on your immigration status, and we'll give you pointers how to maximize your opportunity, minimize the damage, improve your odds in dealing with it.
Yeah. Well, Sam, you started with a question. I'm going to try to give an answer immediately, at least a general answer. What do you do? And for me, this is going to sound like such an attorney answer. You talk to an attorney. Depending upon how serious the issue is, and well, I guess I think for people who are in the immigrating community, it's a criminal attorney as well as an immigration attorney. Why both? Because you talk to people who are knowledgeable about a subject, and not every immigration attorney is going to be knowledgeable about criminal stuff, and not every criminal attorney is going to be knowledgeable about immigration stuff. So why do you talk to an attorney? Well, one, on the criminal side, a criminal lawyer can do black magic and make things go away. And if things are dismissed, generally speaking, odds are that's a good thing for immigration purposes as well. The problem with just dealing with a criminal attorney alone is they may be able to use their magical attorney, not magic, but their charm and their knowledge to get a case taken down from crime A to crime B, but where those criminal attorneys may not have the knowledge is, hey, what are the immigration impacts of crime B? Sometimes what looks like a good deal for criminal purposes might not be the best deal for immigration purposes, because crimes have impacts beyond just the criminal aspect for immigrants, is the bottom line. So
in the world of law, there are specialized lawyers in criminal issues, and there are specialized lawyers or focused lawyers in immigration law, right? And rarely do these overlap, and they do exist. Yeah, they do exist, but rarely do they overlap at a level of proficiency enough to be able to be good.
That's a little bit of knowledge, and usually I want that knowledge to be, I know enough such that I know I need to bring somebody else in. Yeah.
So I mean, without digressing too much, but the gentleman that I talked to this morning, nice guy, and he said, I want to be very honest with you, Sam. You're not the first lawyer I talked to. I talked to more than one immigration lawyer, and I said, I 100% encourage you to, after talking to me or before you're talking to me, you talk to another lawyer and so forth and so on. But to my surprise, and I have to be frank, he did not get a very good advice I mean, he didn't get a bad advice, but he did not get an advice. There was no insight was given to him from the first consultation he had, where the attorney was telling him, wait until the last minute and then file your H-1B extension, so they are not going to, figure it out, or some kind of weird advice. And therefore, talk to more than one lawyer in the immigration area and also in the criminal area before you make your decision, because that can make a big difference, because not everybody is good at this in this area. Really, that's the really bottom line.
Yeah. I mean, I usually tell people when I'm doing a consultation and they start asking me about things I'm not really an expert in. I usually tell them, part of me being good at my job is knowing when I don't know something. So I'm going to tell you I'm not the best guy to answer that, and that's how I think really every attorney should be doing it. Yeah. So Sam, you sort of talked about, I think probably maybe the second most common criminal question, out there. Is a criminal matter going to impact my H-1B? My short-term or L or whatever short-term working visa you're on in the United States. And so when I talk to somebody through this issue, my first thing that comes up is, well, that I-129 form for your H or L or O, that's signed off by your employer. And nowhere on there does it ask, has the beneficiary ever been convicted XYZ? Because first of all, the employer doesn't have that knowledge. And second of all, it just doesn't. And I guess my sort of first level of, is that most criminal things don't come up in non-immigrant visa applications. Now, they definitely can come up. We were just talking about an RFE we have in our office where somebody's, getting that sort of question right now. But usually, sort of smaller potatoes criminal things, I don't really see requests for evidence about them from USCIS. And I know they're out there because I usually learn about them at the green card stage, where things get a little bit more serious and you're going to be signing the forms yourself and you're going to have to disclose those things. Yeah.
So in my mind, Brian, I have two boxes when somebody talks to me about criminal-related concerns. Handling it at the USCIS within the U.S.
Mm-hmm, that's a good point, yeah.
And then handling it outside the U.S. for stamping.
I thought you were going to say, the non-immigrant box and then the immigrant box. Well, those boxes are good as
inside each one has two small boxes.
You're right. I was not thinking about the consulate box.
So the consulate can, and this is one thing I spend a lot of time counseling on, which is the question of my visa got revoked.
Yeah. You'll wake up one morning and have an email box from the U.S. consulate in your box from U.S. consulate and wherever you got your visa saying, hey, your visa's revoked, you're done. And I probably get, a couple calls a month about, oh my God, what happened, how am I okay to stay in the United States, that sort of thing.
So let me flush that out real quickly, outside the country. So you could be inside the U.S., and you can get an email that says your non-immigrant visa is revoked, your J1 non-immigrant visa is revoked. And the reason I'm saying J1, because I recently helped a doctor deal with that. He had this issue, and we were able to resolve it. Your H-1B stamp is revoked. Your F-1 visa stamp is revoked. And contact us to set an appointment to see if that can be reinstated or if
give you a new visa.
Because you have a due process. Okay, you have a due process to appear before the consulate, and the instructions the consulate has is that they're not supposed to revoke a visa without due cause, except for a charge in drunk under
alcohol-related
DUI.
driving offense. Yeah.
Then they, in the Foreign Affairs manual, they must revoke it immediately, because the fear is that you are going to injure a U.S. citizen in the U.S. So you really need. This is not really a criminal question a lot of time, because the revocation happens before there is even a decision.
Yeah.
So the moment the incident happened, the moment there's a case in court, you will be surprised that the Department of State has an office that tracks all these databases across the U.S., and you're going to get an email that says, not guaranteed, but more likely than not, that your visa is revoked.
Yeah. That's now, the visa stamp that is in your passport.
Your stay in the U.S. is not affected. and that's the most important thing you should know, is not affected.
Yeah.
It's when you leave the U.S., you cannot now come back until you appear before the consulate and address that issue.
Yeah, so
And that's a completely different discussion.
very common issue of somebody gets an email from the Department of State saying your visa is revoked, but what it doesn't mean is that your status in the United States, as evidenced by your I-94 from Customs or from USCIS, that is not going to be revoked. That cannot be revoked by the Department of State. It's not within their power. Now, I know that to be true. I guess the Department of State knows that to be true, but a fun fact, this is something how issues like this can manifest in non-immigrant visa cases. I can think of a fella here on an E2 visa who had his visa revoked by the consulate, and that shouldn't impact his E2 status, right? But he got an RFE from USCIS saying, we see that your visa at the consulate's revoked. How can you possibly be in status in the United States? And that's one I saw about a year ago, and our colleague Attorney Joe was dealing with one of those in the last week.
They don't even know the
They
law.
don't even know that. And you have, that's something that I take for granted as an immigration attorney. Oh no, USCIS, the visa revocation of the consulate doesn't impact your status in the United States. Do you have any idea, Sam, how difficult it makes it to find a good citation, a legal citation, to explain that to somebody who doesn't know? It's a significant research.
Because one of the most obvious things in the world.
Yeah.
So the revocation does not invalidate your status in the U.S. So that's something that you should understand. But be aware that departing the United States and coming back might be a challenge. And in our friend's case, he was a medical student and had an issue, and he departed the U.S. and we made an application and we put a very solid presentation, and he was reissued the visa.
Well, I don't want to hammer on the difference between what the consulate does and USCIS does too hard, but don't take for granted that if USCIS keeps extending your H-1B or L or O, that the consulate's still going to be happy to issue you a new visa. They are not beholden necessarily to what the other one has done as well. So, topics hit so far then.
Yes. So I know you got on your list, the first thing is conviction.
Yeah.
It's on the list there. And we don't want to get ultra technical, but I think it's worth mentioning in passing that conviction is a term that is a lot more encompassing in immigration law than the conviction you think about when you say, well, I wasn't found guilty, but you may have had a diversionary program, deferred prosecution program.
Yeah, so for most purposes, you start having problems in immigration if you have a conviction, and that's, well what's the conviction then? And you mentioned, diversionary programs, which might result in, a case dismissal in court, but if you take say you're guilty and take a punishment, so they will dismiss the case, for example, that's the sort of thing that can be considered a conviction.
Yeah, and when you go to court, you have three options to plea.
Yeah.
You plead guilty, you plead not guilty, and then there's a third one here in the U.S. called no contest or nolo contendere, right?
Nolo contendere when you're feeling fancy, but
yeah. Basically, but nolo contendere is the kind of in between, not guilty, guilty, and then there's one in the middle. That one, for immigration purposes, is a conviction.
Yeah.
And what nolo contendere mean, or no contest mean, is that, Your Honor, the facts are right, but the application of the law may not be correct. Well, you've already admitted to the facts. The moment you admit to the facts, and if the elements of the crime, for example, blood alcohol test, breathalyzer test showing alcohol level of XYZ percentage, all those facts, once you say nolo contendere, you've already admitted them. And that gets you a conviction for immigration law purposes. Yeah. So when in the criminal attorneys say, well, we'll just plead no contest and then we'll just negotiate and we'll just get you out of it, you already are convicted for immigration law purposes if you pled no contest or nolo contendere. So be aware of these nuances. And the reason I'm bringing this up, not to make you an expert in immigration, in criminal law or in immigration law, but to make you aware that your criminal attorney may not know the nuances of immigration law enough. Now, some do, but some don't. And you need the help of an immigration attorney to walk you through the process.
This is not just an issue of really kind of the intersection between, criminal law and immigration. This is one that I hit recently in the terms of business law and immigration. Somebody getting advice from their business advisor saying, "Oh yeah, everybody starts their business this way in the United States. Go ahead, do your business that way." And you come to the immigration attorney and say, "No, you can't do it that way because it's incompatible with your visa." Well, again, it's part of knowing talking to the right people about what you know about.
So what are the crimes, as we're running out of time here,
Yeah.
we don't want to spend too much time. We promised that we spend about 20 minutes, and we're at minute number 15 here. What are the crimes, Brian, that create the biggest concern in immigration law?
Well, for me, I'd say the ones that we encounter most for normal sort of professional people immigrating to the United States, probably crimes involving moral turpitude and domestic violence, which can probably be considered a crime involving moral turpitude as well itself, but those are the kind of the big categories for me. Would you agree?
Yeah, the domestic violence one is the one that catches people by surprise.
Yeah.
And I see people who are highly educated, highly intelligent, highly accomplished find themselves in trouble with it.
And domestic violence can make you deportable from the United States. They can put you in removal proceedings.
Even if you have a green card.
Yeah, yeah.
Even if you have a green card. And
why does it surprise people so much?
Because some people, people from one culture to the other come in here in the United States and they behave in a way in their culture that's not acceptable in the U.S. And also the domestic violence, sometimes it is very broad. For example, stalking.
That's on my list. Yeah, stalking something.
So what's a stalking? Stalking is when you follow somebody or track them. And that is a crime here in the U.S., unacceptable. And it's a domestic violence, and it becomes deportable.
Yeah.
It's huge.
The other thing in sort of the scope of it's bigger than people think is the victims. It can include former spouses, people who you share a child with, and people who you otherwise cohabitate with. So it's not just, your
girlfriend.
It's a bigger scope than that.
Yeah. My consultation with this Chinese student some time back, he went for F1 visa stamping, and he had a fight or something with his girlfriend in college, and it was dropped. But there was some domestic violence, and there's some admission there may be no contest plea or something that he pled, and the officer was so quick with her fingers. Pulled that case online, looked up his name, what city you found, and found the case, immediately denied his F1 visa, and that was the end of his student visa life in the U.S. because it's domestic violence. And the thing that gets people really upset here, like the officers and so forth, is if it's involved a U.S. citizen, female. They don't really like it. It becomes personal for them. But it doesn't matter. It's the other way around as well. It's unacceptable. That as it may. But domestic violence is one thing people get tripped in it all the time. And it's one of those painful cases.
It's people sometimes think it's between me and the people in my house. Well, it's when the police get involved, it becomes a serious immigration matter. The other thing, we mentioned domestic violence. We also mentioned crimes involving moral turpitude. And the way I choose to explain crimes involving moral turpitude, it's anything that we find morally reprehensible and there's a crime for it, that can potentially make you ineligible to immigrate to the United States.
Shoplifting.
Yeah.
Is a big one. Again, I have handled a case successfully for a wonderful lady, and she was innocent. But here's what happened. Baby in the cart, he's crying. She grabs something from the aisle to shut him up, gives it to him. Now he's playing with this thing, right? Then he drops it, falls between his legs, behind him somewhere in the cart. She's not paying attention. She's being watched. She stopped on the other side and accused of shoplifting, which is theft, which is a crime involving moral turpitude, which is a deportable offense or grounds of inadmissibility, which gives you a denial for your non-immigrant visa or your green card.
Yeah. Now, there's all sorts of exceptions. There's like the petty offense exception. There's a political offenses, but it's the sort of thing where, again, that's not an issue of criminal law. Whether it's something's a crime involving moral turpitude is a matter of immigration law, and that's why you bring sort of an immigration attorney in to talk about those things.
And just to make everybody comfortable with the story I brought up, it was ended in a very positive way, where the case got dropped, because what happened is, in the case like this, is now you educate the criminal lawyer about, and we had a good criminal lawyer on our side, about the consequences, and that this is not the kind of cases you negotiate or plead to something that also has some kind of a moral turpitude. So they called for a full jury trial, and the day of the trial, the prosecutor backed out.
Lovely.
And dropped the case.
Well, you reminded me of a scenario, and I'm going to maybe make this start wrapping up what we're talking about. It's a good way to maybe close this thing up. It's sort of, long-term implications, and, can you ever get rid of it? And I guess the question, can you ever get rid of this for immigration purposes? The answer is effectively no. Why? Because, it's possible in the U.S. court systems to seal or expunge certain offenses such that, they won't appear in background checks, and you say adios to it. If you call the police and ask them about it, they won't say anything. If you call the court and ask about it, the public, they'll say, nope, no records of such a crime. But those things still have to be disclosed for immigration purposes. When you get to filing or a visa application, something you sign yourself, or your I-485, when you're applying for a green card, we sign that yourself. You're going to be asked, have you ever been arrested or convicted of a crime, whatever the question says at the time? And the answer will usually explicitly on the I-485 says, and we don't care as to whether or not it was expunged or sealed. And meaning you have to, disclose these things to them. Meaning, I'll tell you the story. Back in October 2020, when we were doing that wave of green cards, one of our paralegals was doing forums, and came to me and said, "Brian, this person contacted me. They said they only want to talk to an attorney about this." And I said, "Okay, I'll give them a call." And she was very, very paranoid about it. And she whispered it into the phone because, "Brian, I have a criminal thing." It was a shoplifting thing. And to the best of my knowledge, she has her green card now, but it's the sort of thing where, no, I don't care if it's sealed. I'm an immigrant. I don't care what your criminal lawyer says that it's sealed. It's not a record. It's not a record. Nobody will know. The immigration lawyer, I'm the expert in what I do. It's right there on the forms, gang. You got to disclose these things. And
expungement does not help.
Yeah.
It's basically wasted process, but you can expunge it because it helps you to be able to say no on job applications.
This is true.
So expungement has positive things, but not for immigration law. It is completely, that expungement is completely opaque.
The government.
Or non-opaque. What's the word?
Transparent.
Transparent. Transparent. Non-opaque. Transparent. Yeah. So yes. Now, 23 minutes. I cannot resist but add one more thing.
Who are you, me?
One more thing. Number one, we haven't covered everything. This is just an overview. Yeah. But the thing that you should watch out for, Brian, in my opinion, right now in the current environment, is marijuana-related offenses. Under federal law, marijuana is a prohibited drug, and the use of marijuana will get you deported. I don't care if the state of Massachusetts allows it. I don't care if the state of Ohio allows it. I don't care if the state of California allows it. Brian.
You bring it up in, the conventional sense, the recreational use of it, possession of it. But I'm going to give my public service announcement. Don't get involved in work in that industry, regardless as to where it's legal, because as a federal matter, I can think of a couple people whose metaphorical bacon I essayed by, reading their H-1B petition and saying, wait a minute, it looks like that client you're going to be working with is somebody in the marijuana industry, and they are, and it's basically you are getting involved in, essentially the illegal drug trade. I don't care. If you're the IT person for the marijuana company, you're still working for what in the eyes of federal law is a criminal enterprise. Yeah.
So it could be 100% legal in your state. Under federal law today, it is an illegal drug. And it is grounds of inadmissibility. And has not changed, and you stay away from it.
Very limited exceptions to it. Yeah.
So 624, we didn't go too much over. I hope we're able to give people some advice and guidance on this issue. And see if there's a couple questions on this issue or other issues.
Yeah.
Happy to answer.
Yeah, we got a whole lot of them.
We begin by telling everybody we don't know enough about your case to give you a comprehensive advice, and therefore, don't assume what we tell you is 100% accurate because we don't have the whole picture. Discuss it with an attorney of your choice that can give you a more comprehensive advice, and therefore there's no attorney-client relationship established here because we're talking to you. And without further delay, let's take the first question.
Yes, let's see what we got. From RK, what would be wrong if there's an immigration reform and Congress eliminates all work visas replaced with conditional green cards? After 2 years of working in the occupation, you can remove the conditions for the permanent. I got to move this over here, Sam. We're never going to read it.
So I can't, yeah.
Oh, I will.
Yeah, we'll fix it. It's okay.
Think about that.
We'll work on it.
Sam and I have been messing around with our setup here. We're still trying to find the optimal monitor layout. Maybe if I clone that one over there, would be the way to do it.
How about if you switch this screen to this screen and this screen to this screen completely?
Meaning, well, can you read them if they're up here?
No.
No?
That's okay.
Okay, well, I'm going to put that up there. I'm going to try one more way to do it. I'm going to try and change the zoom so maybe I can...
Yes, maximize the screen.
Oh, there you go. How about that? Is it readable right there in front of us, right?
Yeah, a little bit better, yeah.
Okay, there you are. So after 2 years working in the occupation, you can remove the conditions for the permanent green card and make freedom of movement between Mexico, Canada, and the U.S. similar to EU.
Well, I can tell you what the problem with it. Okay.
I can think of some great knee-jerk reactions for sure.
My first knee-jerk, absolutely. The biggest problem with it I have is very commonsensical. And we don't do anything with common sense here. So yeah, absolutely. Why not? But I mean, there's a lot of things that we can do differently, and this is one thing that can be done. And many other things, it requires Congress to act, and Congress and the president oftentimes are of the opposing parties, and the Congress is not going to pass a law that's going to make the president look good because they want them defeated in the next election, and therefore we don't have opportunities. The opportunities to come out with a common sense change are very minimal, and that's the problem we have.
Yeah, I mean, I can think of certain people I would tell that to, and they say, well, that just sounds downright un-American. I don't want freedom of movement between, Mexico and Canada and the United States.
Well, freedom of movement for them.
Well,
so they can travel. Not for everybody.
I don't know. No, they say and make freedom of movement between Mexico and Canada, the U.S. similar to the EU, like member.
But as it relates to their permanent residency, their green card, I think he's not changing the law. He doesn't care. I mean,
he's not going to Mexico or Canada either.
He's not trying to unify Mexico and Canada, but maybe he is.
We say similar to the EU. Maybe he's talking about like a Schengen area travel zone.
Well, there is I can see an opportunity with Canada. I cannot see it with Mexico, because obviously that's one of the reasons. For example, Turkey is not part of the European Union because the economic conditions in that country are of a great disparity than the rest of the European countries, for example, and so forth and so on. But yes, good suggestions, and send it to Congress. Maybe they'll do something. All right, let's take the next one, Brian.
Yeah, it's from Zoomer. Can you please predict my AOS priority date? April 27th, 23, rest of the world. A nurse with a TN visa applied via EB3, I-140 approved.
Rest of the world.
Yeah, well, I realized I was about to bring it up here, but I do have printed copies of Visa Bulletin for us. So, April EB3, rest of the world.
Oh, it's not too bad. It's
that's
November 2022.
Well, that's the
final election rate.
Yeah, I'm looking at the dates for I don't know if this person has filed for AOS, because I mean the dates for filing are only in March 2023. That's only about 2 months off, essentially, March 1st, 2023. So, it doesn't sound crazy for me that comes up within this fiscal year then, right?
I'll buy that.
Yeah, that seems possible.
Zoomer, we think for that scenario, filing the adjustment of status should be within this year, and the green card issuance, 2022. to 2023 is a year, so I'd say within 18 months.
Yeah, yeah. I mean, it seems like you could probably file this year, and maybe, you know, if not this year, definitely it seems highly likely in the next fiscal year is what I would say. I mean, because the dates for filing, if again I'm thinking about what the dates for filing are supposed to be, they're supposed to be predictors of where they go. So if they're only saying March 1st, 2023 on the dates for filing,
1 month off.
Yeah, yeah, but that's for dates for filing, which are supposed to be a predictor of where it's going to go for the foreseeable future.
But
right?
nobody knows.
Well, yeah, it's not crazy. Like, I wouldn't be surprised if it came up this year, and next year I'd say, well, yeah, probably,
Highly likely
yeah.
next year. Probable this year.
Yeah.
Likely this year.
Yeah.
Very probable
Yeah.
next year.
And then you're in the processing times for a green card once your priority date's current, and I'd say you're betting on about a year from there. Yeah.
Yeah, sure.
Yeah. Cool. So from Chandrakanth. Hello, sir. Can we do multiple jobs after AC-21 on green card EAD? If so, is there any preference as to who would provide the I-45J?
Excellent question. So number one, the green card, I'm going to call him the green card employer.
Yeah.
For simplicity, that you can be working for, it has to be full-time, permanent position.
Yeah.
Okay. So full-time, permanent. Now full-time, by the federal government, defined at least 35 hours, but it's really as defined by this employer, but typically not less than 35 hours a week. So 2 part-time jobs will not add up to a 1 full-time job, or 3 full part-time jobs do not add up to 1 full-time job for the purposes of the green card application. But there is a way around it, which is self-employment.
Yeah.
So you can work for yourself, give yourself a salary, and contract yourself out and do a self-employment. So that's the one way around it. But if you are going to do, let's say, 2 full-time jobs, the one that you believe is permanent, the one that you believe that's same or similar job qualification, and the one that you believe you're going to be staying with, if you have to choose between the two, would be your I-45J provider.
Yeah, you sort of expressed the same word I was having, Sam. It's basically, if you have, you know, a part-time job here, part-time job here, part-time job here, there has to be an employer that is going to be sponsoring your green card, permanent full-time employment. And if you can't, if you put all your eggs in different baskets, you don't have an offer of permanent employment. But you can gather all those up in under your own business of you incorporated, properly incorporated company owned by you, and suddenly relationships with multiple people can turn into a full-time job with, you know, on a contractual basis. Yeah.
Yep.
Yeah.
I agree.
Yeah. Ajay.
My priority date is EB2 September 2012.
Yeah.
Wow.
It's a pretty old one.
Yeah.
I mean,
I'm surprised.
I like it as soon as we get halfway through the sentence, we see priority date, we can't resist looking it up.
Yeah.
So India, final action dates are in July 2012 for EB2, and if you were an EB3, you'd be current, which is something interesting to think about, because final action dates November 2024, well, the next coming month. They're in July 2012, you're in September, and EB3 is in November 2012. So I changed my job recently in September 2024. Should I file my I-45J now or wait till it becomes current? I was thinking that I file it when current, my application will be picked immediately. Well, when is it required? Let's maybe answer the question. Is there any requirement as to when that I-45J must be filed?
I think there are 2 questions. What's required and what's really best.
Yeah.
When it's required, I think when they issue a request for evidence.
Yeah, that's really the only.
And I do not know. I mean, 2012. If you, I mean, he could have a very fresh adjustment of status.
Yeah, that's true.
File, we don't know. But if your adjustment of status is stale, and you've changed jobs, more than likely you're going to get a request for evidence. Yeah. So you can probably do it then, or you can do it preemptively.
Yeah, I mean,
I like the preemptive approach.
I like the. I mean, that's the. Yeah, he was thinking wait until his application is current, but can you avoid the adjustment, the RFE that way? That's kind of what's in your. Can you avoid the RFE? So it seems possible you can avoid an RFE if you send them a supplement J preemptively if your case is up to date, and when they pick up your case and your date's current or about to become current, they'll say, "Oh, I have everything I need. I can just approve this thing."
I don't know how old is the adjustment,
Yeah.
but it is unlikely that he is going to avoid the RFE because it's almost always a matter of course if it's old enough that they just want to update on a lot of stuff.
Yeah, yeah, they can do that. I mean, medical exams another issue that could be out there for this person based upon the age of the case.
They open a file that hasn't been touched in 5 years. They want to say hello
Yeah. Yeah.
before they hand the green card.
Supplement J is a great hello. It's a great howdy,
Yeah,
Sam. It
yeah.
says, you know, if it's
Sure.
an employment-based green card, what's it about? It's about an offer of employment. A nice shiny, you know, I got the supplement J last week. It's a pretty good.
Sure.
I mean, I do concede the point that you can't anticipate all the issues that they could raise at any time. Meaning, it's impossible to guarantee you're going to avoid an RFE. That's for sure.
Yeah.
They can do it at a whim. They can do it.
They want to make sure that you've maintained your status. For example, they don't have good records, so show us your I-94, show us your EADs.
Yeah.
You know, so there's no gaps.
Yeah, that's a very common thing. Getting a late I-45 RFE about your employment authorization. Once you file your I-45, you don't really have a status issue, but you can work without authorization, and that can, you know, render you ineligible for adjustment of status if you go beyond the I-45.
Potentially.
Yeah.
Potentially, yeah. So there are issues, but I would do it preemptively and pray.
So another question from Ajay here. What's the process for address change? Is filing online through USCIS efficient? I have a pending I-45 at this point. If you do a Google search for USCIS address change, you will find the USCIS address change page where they will tell you that they want you to do it through their online portal right now, which is a pain in the butt to use, but I guess the thing I would most think...
You have to create an account.
Yeah, you have to create an account.
You have to create an account, and you have to do it through your account, and you have to reference the adjustment status.
That's the most important thing. It ensures that you get your RFEs and your approval notices and ultimately your green card.
Yeah.
Oops, there goes my microphone. I guess this is when I do the public service announcement of when are you required to notify USCIS of your change of address, Sam Shihab?
Oh, that's a good one.
Yeah.
Whenever you relocate, within 10 days, I believe.
Yep, 10 days, yeah.
If my memory serves me. And that extends to U.S. permanent residents as well.
Yeah.
They expect it by electronic filing, and unfortunately, the violation of which could be a misdemeanor.
Yes.
And more as well.
Yeah. I've only seen that prosecuted a case of it once during my career, so I'm closing on 15 years ago. I know you say they did that a lot after 9/11 to basically chase people down who they deemed undesirable.
Yeah, they put people in deportation because of it. Yeah. But that's a different time, you know.
Yeah.
Crazy times call for crazy measures.
Yes. So, here we go from Migranyan. Is there anything that can be done about backlog in TSC for AOS other than mandamus? Some centered using all the numbers, and lazy ones are not doing anything. So I think the question is, you know, the processing times for the Texas Service Center are quite high.
Yeah, it is.
And it's something like 60. Well, I can look it up right here.
It's the worst.
Yeah, it's pretty brutal. I know that Texas Service Center here. For employment-based adjustments, Texas Service Center. What do they say in the processing time is right now? 30 months versus, I'm going to just check out Nebraska here right quick. 14 and a half months. That's rough. Yeah. Well, Sam, can you do anything outside of mandamus action?
You can try, but honestly, the ones that I see most productive are the mandamus actions.
Yeah, mandamus actions are
And
productive.
it also depends on the prosecutor and what state. Some people will fight you more than others.
Yeah, yes. We've been on a mandamus kick this year, and we are finding ourselves very happy that we do most of our work here in the Columbus area, where I was told when I became a member of the Southern District of Ohio, the federal bar for the Southern District of Ohio, that it was one of the most collegial and friendly jurisdictions there is. And that judge was right. The government attorneys here treat people they treat us with respect, and thereby they of course get the same from us, and we get things done here in Columbus for sure.
Yeah. We also do some decent number outside.
Yeah.
And it's a little bit rougher.
Those get me angry to some of the things we've been hearing from.
But we don't care. We don't care. Bring them on.
Sam, I do care. I care. I care, and it makes me want to fight them more. I guess that's the point. The point I'm making.
Yeah. I'm kind of maybe desensitized. Just bring it on.
Oh yeah, bring it on. Indeed. I'm just coming at it from how dare you sort of perspective, not care about this.
Yeah.
I'm an immigration attorney, darn it. If I care about it, you should care about it. So just say thank you from Ajay. So.
You're welcome, Ajay. We appreciate it.
Yeah.
All right, next one, Brian.
Yeah.
What are your thoughts? Why dates progression in the bulletin is unlike past years during first quarter of fiscal year? Is the season that they are only issuing approximately 800 per country per quarter? Thank you. Our answer is pure speculation. We are not in any insider information source. We don't have that.
Yeah.
I don't go have dinner with those guys or go on the cocktail parties with them, but we have our theory.
Yeah.
Informed decision or informed opinion, if you will.
Yeah.
What's yours, Brian?
Well, we are dealing with somebody relatively new in the task of, steering the ship that is the Visa Bulletin. There's a guy, that Charles Oppenheim guy, who he has retired and done what a government employees do sometimes, has gotten a private, sort of consulting job, it seems, working for out there, advising people in the immigration community. But there's somebody new there doing this job, and I guess that's it. They've been there maybe about 2 years at this point. I'm not even sure they know their name. It's something I should probably I want to look up sometime to see if they've named who's responsible for that, because it wasn't a public piece of information. But different. I don't really have a great answer. Different people doing different things. I guess one of the things I'd say, go slow so you don't disappoint people.
So our partner Cheryl Brico thinks it's all political.
I don't disagree with her.
Well, she doesn't say it's all political. She thinks it is somewhat political, meaning that if they want to move the dates, they will find ways to move the dates. But they don't seem to be interested in moving the dates.
Yeah.
Throughout the history of the State Department and Homeland Security, there has been times and there was great tension. And when there's great tension, and there's distrusting each other, I think the system works better because they question the data, because the data comes from USCIS and the State Department issues the dates. I think they're right now in a great harmony.
Yes.
They're just high-fiving each other and they're working like brothers and sisters, which is disadvantage us, the consumer, because there's no tension enough between them to keep each other honest about these dates. I'm
going to bring up the classic example of this. It's back 2015 or so, when there were no dates for filing on the Visa Bulletin, and then suddenly, 1 month, there was dates for filing. That's when the Department of State said, well, I don't care what you're doing, USCIS. We said we're going to start taking cases for filing early, or so we can get these things processed, so we can give people green cards timely. And nobody knew what it meant for a while, and was USCIS required to take cases earlier than they wanted. It caused a big old rush, and ultimately they again found harmony on more or less.
And
on the
back
issue.
2007, the State Department said, "You're not giving me good data. I'm going to make everything current."
Yeah.
So they flipped the switch and they opened the floodgate on USCIS, and the USCIS got buried.
Yeah, and yeah.
So they made everything current. And then USCIS pulled all the numbers overnight. They pulled all these officers to just go on the computer and call all these numbers, like just hitting the computer. And USCIS, the Department of State, issued an interim bulletin at mid-month, freezing everything because all the numbers were called, not by assigning them or by reviewing cases, it's just by hitting the keyboard 1,000 times over. And the American Immigration Lawyer Association sued USCIS, and they reopened it for 14 days, for the number of days they closed it. But that's when there's tension between Department of State and USCIS, and I think we get better service because they're just distrusting each other, and therefore they cannot team up and say, let's have an easy month, let's have an easy year. Who wants cases? Who wants to work hard? So what if we lose 20,000 cases at the end of the year? So, so I'm not saying there is that, but I suspect there is that right now, and that does not help us.
Yeah. I was just thinking of an interesting nuance of the big 2007 kerfluffle. It's that would be the tail end of the George W. Bush administration there, which sort of goes to say how how immigration can create strange bedfellows. Right now, the most recent Republican administration we've had was not pleasant for immigration, but interesting things can happen during them as well.
So moving dates forward also create opportunities to move things backward. And somebody who wants to go home and wants to not be criticized believes that moving them forward slowly may be a better approach, even though we're risking not getting cases approved by the end of the year. So, I mean, these are just opinions and discussions, not necessarily confirmation or facts, if you will. All right.
So, we got here from Ala Aoun.
Dear gents, my adjustment status submitted almost 4 months ago to NVV. Yet I haven't received any biometric appointments nor any update regarding work authorization, advanced parole. I received the receipt though. All right, so the national was NVV.
I don't know. It's either Nebraska Service Center maybe, or the national.
They keep creating more offices. Anyways, you received it, but you did not receive the biometrics, and I would be curious to know what kind of case it is.
What's the ground?
Yeah, is that a family case? Is this an employment case?
Part of me,
4 months, it probably should be now getting about an EAD. Biometrics probably should also have been received by now.
Maybe it's thinking the NBC, maybe it's a National Benefit Center. I would note the B and C are right next to V on the keyboard, so maybe a bit of fat fingering there. Maybe it's a National Benefits Center there. Okay. So I guess I would say this, if you don't want to worry, one, you have a receipt notice. As long as you're checking those cases online, seeing that they're still in process, great, they're still in process. You don't have to worry. I mean, I worry about, you're not getting RFEs, for example, getting a denial. EAD processing time, presuming you're at the National Benefit Center, is 6 months. Meaning if it's been 4 months, you're still within their normal processing times. They're not going to consider that. Now, the more depressing one is going to be the I-131, the advanced parole.
14 months?
Let's find out. At the National Benefit Center, 10 and a half months. Coming down just a little bit, but still painfully long. So those things are normal. Biometrics, they can waive biometrics. And there you go. But they usually send you a notice of, they would sometimes send you a notice of waiver of biometrics.
You got a receipt notice. That's good news. That means your case, nothing wrong with your case.
Yeah.
I'd hang in there a little bit more and then start doing inquiry.
That EAD should pop up in a couple of months is the bottom line. Yeah.
Yes.
Yeah. So, from Pradeep.
I've been arrested DUI 2012. Case was dismissed. I'm on H-1B visa.
So what about a 12-year?
What about a 12-year arrest record?
Yeah.
So, 12 years is a long time. So you should be congratulated for being, up straight and doing the right thing, Pradeep, for 12 years. That's an accomplishment.
Yeah.
The length of time doesn't change anything. So we're dealing with the same issues. Yeah. Case was dismissed.
That's good. That's great.
But was there a...
How was it dismissed, I suppose, yeah.
So was there a diversionary program or a deferred prosecution program? There are different names in different states. Yeah. So those are relevant to whether or not there has been a conviction, because so you need to have that looked at carefully, because there may be a conviction even though the case is dismissed. But a single DUI, there is no injuries involved, there is nobody in the car, there's no children in the car, there's no children hurt, there's no...
Yeah. You're just listing off all those different sort of factors that, could turn it from a DUI to a big problem
moral
DUI.
turpitude,
yeah.
kind of an offense. So a simple DUI, done, finished, will have typically no impact on your H-1B as proven by 12 years of renewing your H-1B, and should not have an impact on your green card as well. The question is how to answer the adjustment status question.
Yeah, well, you're going to have to, the answer is you're going to have to answer that adjustment status question. It is not, it is in the past, it's 12 years in the past, that's awesome, but it will rear its head again when you apply for a green card. You will be asked the forms.
It's not a big deal.
Yeah.
Just you need to bring it to the attorney's attention, and the attorney should help you answer it correctly.
Do you think that he would be more likely to be interviewed for his green card?
12 years? I don't think it's going to be relevant.
I think he will.
Okay.
I give it a pretty high degree of certainty that
he'll be interviewed.
Okay, that sounds really, really confident. I give it a 75% chance. Well, all that matters is
12 years. That's why I'm thinking is so long ago.
They do like to. I've been to plenty of interviews for old DUIs. I guess is my counterpoint.
So get ready for an interview, Pradeep.
Yeah.
I mean,
that's not too bad an interview. I mean, I guess a dismissed case. I see your point. I'm sorry. I always forget this is dismissed. If it's dismissed.
But it depends on how it's dismissed, because I know the last one I remember also, this young man selling cigarettes to a minor. They called him for an interview, and they held up his approval for a long time because of it.
Yeah, I could think of them.
But this officer was not really the most intelligent officer, and this is the problem. If you get a smart guy, you just will move it along. They understand it.
Yeah.
If somebody who is completely stupid, and there are stupid officers, there are stupid lawyers, there are people stupid in every profession.
Yeah.
And if you get one of these stupid guys as an officer, then you may have a little bit of difficulty, but nothing that will prevent you from getting your green card, in my opinion.
Yeah. I'm not terribly worried about that in the long-term regardless, even if it was a conviction. So from Narek. Hello, Sam and Brian. I'm an F1 student with an approved I-140. Have been in the same college for 5 years. Within those 5 years, I completed the RN program and did a year of OPT. My priority date is 6/7/2023, EB3, rest of the world category, and I want to extend my I-20 for another year in the same school. Can staying in the same school be an issue during interview with USCIS if they call me?
Excellent question. So there is an immigrant intent by filing the I-140, but she is renewing within the same school.
Yeah, so you're highlighting the fact that student visas are a pure non-immigrant intent visa, and that if you're filing an I-140, you've waved your flag to the U.S. government saying, I'm intending to immigrate. Sure.
Yeah. So it has been the unwritten policy of USCIS is not to disrupt a student visa status or renewal thereof within the same school.
Yeah. Within the general student visa program, it's usually where I'd be concerned is when you're coming to USCIS for things. But
anything that does not require filing with USCIS, because it changed. So you're maintaining F1, you're just extending your F1. You're not filing a new petition where an officer is looking at your paperwork so they can make a decision. They're not making a decision. They're just basically continuing your current status without filing an extension of any sort. These types of extensions are no problem. You mentioned you're getting your OPT, right?
I have found...
Did she say OPT?
Yes, the person did have an OPT, and I have found that people, they do... I can't... It's something that stresses me out, but I have seen anecdotally people approving OPTs for people, where people have I-140s approved, which seems,
So I am interested in Narek sharing with us whether she got her OPT after her I-140 was filed or after it was approved or filed. That will be helpful because it is a filing with USCIS, and the information is not 100% confirmed that is going through on a consistent basis at least. But since the OPT is really nothing but a continuation of your F1 status and you're not changing your status, normally that's not a problem. And that's what we see. But I'd love to hear from Narek to drop us a note and say, yeah, I got my OPT after my I-140 is filed or after my I-140 is approved. that would help everybody here.
Yeah,
Confirm it.
yeah. I think in terms of are they going to bring that up in an interview? Question.
No.
Yeah, I don't. Yeah.
No, not at all. This issue will not come up in the interview at all because there's no violation of your status.
Yeah.
Well, as I see it, there's no violation.
See, this is as I see it too. But I always worry about that. Massive change in policy. Think about it, Sam. There was the during the Trump administration, the proposal to change the nature of student status so that they would start counting unlawful presence for you from the date you violate your student status, not from the date that USCIS finds a violation. That's a proposal that was shut down pretty quickly. But these things can change how they approach certain things like this, which is something that just crosses my mind.
Yeah, but today, in today's world, right now, and has been for a very long time, there is not going to be a concern about immigrant intent. This is the kind of case I like to recommend that you have a lawyer with you at the interview. I think it's a very little money compared to the benefit you gain, so they're aware of this issue, so they can handle it and keep the conversation balanced, if you will.
Well, a question from Pradeep here. So I need a consultation. Where can I book? Well, I'm going to take away that question and note that we have this lovely URL on the bottom of the screen, www.immigrationvisaattorney.com. Take you to their website. There's a little contact form there.
Yeah, either this one or shehabburke.com. They go to the same website. We have Get in Touch box. You can fill in the Get in Touch. Say, hey, I need a consultation. You submit. Typically, you would receive a response same day or next day, but at the latest from us.
I don't know what it was about that question, but it made me think about something related to our topic of today, the criminal stuff. It's one thing you can do if you have a criminal issue in your past is get the records now. It can take a little bit of time to get proper certified records from a court, especially if there's a sealed matter. And get them now, because they're going to, if you haven't given them in the past, there's going to be an RFE where they request those things. It's nice to have them underneath your hat in the event that they actually do make that request, which they usually do in the event of a criminal case. Even that dismissed criminal case, they're going to want to see the dismissal record.
Yeah, and
I would suspect.
Yeah, throw in like foreign criminal cases becomes interesting because a lot of things in foreign countries are not crimes here in the U.S. And a lot of things in a foreign country that's not criminal can be criminal here. So it creates an interesting dynamics in evaluating those cases. All right.
A frequent flyer here, Wesley. Hi, Sam Brian. Do you foresee a lame duck Congress passing any sort of immigration reform?
Heck no, I don't. Because there is no lame duck Congress. These guys are they're forever. They are elected forever, and so I don't. Yeah, I mean, some of those guys who are not in favor of immigration or anti-immigration, they have been there for many years, and they will continue to be in Congress, and vice versa. So I don't foresee that. Brian, do you have
no? That's I'm on board with that for sure. Yeah. So I just got moved on to the next one. Does USCIS release a spillover numbers for fiscal year 2025? So that would actually be a number that would be released by Department of State, and I think I would have called it if it was on the end of the visa bulletin or the top half of the visa bulletin.
They're supposed to have released it a week ago.
Were they?
Yeah, and they're saying there's some numbers to share, but I've not seen it, Brian.
Yeah.
So that's a great question.
I thought they usually print it in either their preamble on the visa bulletin here, or maybe in the end. But I have not seen that number. That's a headline number. Number. So there you go. Yeah.
So well, hopefully by next week we will have the answer.
Yeah. So from Empire, another sort of frequent person here. DOS states they will be moving to the dates similar to fiscal year 2024. Do you expect more movement this year? Past 2 years, rest of the world, only 4 months. China 2, 10 months in India, EB, India 2 to 3 months, EB3, even worse.
So if the State Department say they will be moving the dates similar to fiscal year 2024, why do you think, Empire, that I would have a different opinion from the State
I would
Department?
just, you know, I have not heard of them commenting on their movement of the visa bulletin for fiscal year 2025. I always like to read sources, so you toss that in the chat
but you
for
know,
us, or,
and also again, I haven't read it, but the word similar tells me, is it similar in policy or similar in the number of months? So that leaves a lot to be desired.
Yeah.
And also, it's a function of how many supply and demand, right?
I don't think they can just sort of rest and say, I'm going to do it like last year because this year is different, you know?
Well, they will do it like last year. They're going to look at calculate the numbers and come out with
use the same formulas, I guess, but you know, different input, different variables, and there you go. Yeah,
it sounds like to me.
Yeah. So let's see here. Yeah, these are the dates. 20 Westeros, never China, India was so there's more sort of follow up there.
Yeah.
For sort of a follow-up for Narek, who was talking about
OPT before filing the I-140. I filed and get approved I-140 while I was on my OPT. It was quick because Schedule A benefit of nurses. Yes, absolutely. Yeah. So her OPT was approved prior. So I was hoping that she can confirm that they're still continuing to approve those EADs.
Yeah. I have seen like cases in the last couple of years when they approve those OPT, those STEM or STEM OPT EADs. I just warn people that it's not. Usually, this comes up in like family cases. You know,
we have a very forgiving administration right now. The Biden administration has been on an approval spree. You know, you can. It's like a buffet. You know,
have your fill.
All you can eat.
Yeah.
Kind of an approval. Has not been like, you know, when we had Trump last time, we had a ridiculous rate of denials for H-1Bs, if you remember.
Yeah.
Yeah.
So, Sam, we have, I think, reached the end of our time here.
Yep.
And we've also appeared to have reached the end of our questions here. A couple repeats there on the end. I think we got to everybody, and I think we got to 7 o'clock.
Excellent.
Think we say adios.
Sounds good. Thank you guys for listening to us. Look forward to seeing you again Monday at 6 o'clock next week. And